Honorable members. Deputy Minority Leader. Deputy Minority Leader. Please, honorable members, may we have your ears. Deputy Minority Leader.
Thank you, Mr. Speaker. Mr. Speaker, I know that, hello, Mr. Speaker, the mention of the former Chief Justice on a Tokonu is not a subject under discussion at this point in time. If you look at the report, I think we are relating the report that has been submitted before us.
He's attacking
the personality of Chief Justice is not something that we have to entertain. So I just call for the expansion of that part, attacking the former Chief Justice, to be expunged from the debate. Thank you very much.
Honorable, please, honorable members, please. I heard her say that as a woman, she was going to celebrate women that were Chief Justices, and started with Her Lordship Justice Georgina Wood, and said so many things about her. I practiced before her when she was High Court judge. I know her very well. Then she proceeded to Justice Sophia Akufu. She was in practice, private practice, when I was also practicing. So I know her very well. Now she proceeded to Justice Tokonu. She is far behind me, so when I was in flight, she was not available. She was saying what happened. Please, she was. Honorable members, please, I have to relate to this before I give my ruling. She was sharing her experience when she appeared at the appointments committee, and that she member speaking was a member of the appointments committee. And she asked her a question about the five attributes of a Chief Justice. And now she's going through what took place. So I was keenly listening to her to see whether she will pass the acid test of our rules. That is why I'm following her keenly. If she doesn't, I'll call her to order. Please, I'm listening. I will not allow her to say anything that is unparliamentary about the former Chief Justice. Please. Yes. Honorable member, you are left with 1 minute, 30 seconds.
All right. Thank you very much, Right Honorable Speaker. So, Right Honorable Speaker, to pick up from where I left off. So this is the experience with Her Ladyship, Gertrude Araba Tokono, to the extent that the former member of parliament, Honorable ABF Hussein, had occasion to speak on Joy News File on the Saturday and said that in his opinion, the most important question that was asked that day was the question asked by Honorable Zuwaira Mohammed Ibrahim. And the Chief Justice nominee failed to answer that question. Now, Mr. Speaker, I'm making this point in order that I can dovetail effectively into my next point. Mr. Speaker,
Honorable member,
Mr.
please.
Speaker,
Please. Honorable member, as you rightly stated, that is the opinion of Honorable ABA Husseini. As to the marks you are giving to her answer, it is not for you to be satisfied with her answer. Once you ask the question, even on the floor here, the answers that are given does not necessarily satisfy the people who ask the questions. You cannot use that as the basis to judge her on this particular situation when she is not in question. We are not here discussing the former Chief Justice. No. So if you are going to celebrate them, and let's move on. Please. Yes, Honorable Dominic Nintini.
Thank you very much, Mr. Speaker. Mr. Speaker, I'm guided.
Difficult. Mr. Speaker, thank you very much.
The record has to be expunged. It has to be expunged.
Mr. Speaker, that tells us one thing. They are not listening to you because they have known that you called me.
Please go on.
Mr. Speaker, thank you very much. Mr. Speaker, I want to really thank you. People who are not here to defend themselves, as Mr. Speaker has said, if you want to say adverse things about them, Mr. Speaker, I want to plead, as you have done, you protect them. So I want to say to you that, Mr. Speaker, as you want to say, Mr. Speaker, that I call on you to let them expunge that particular section so that it does not stay in the Hansard. The section, the point she just made in trying to give marks to somebody who is not here, and even she is the subject of all that we are doing, they should expunge it. Because if there's anything, the record is that she has been our Chief Justice before. And she has cases in court. We don't know what will happen. So they should expunge that portion from the Hansard.
Honorable member, I'm trying to get which portion, because please, what I said was that she referred to the opinion expressed by ABA Husseini, showing that they were not satisfied with her performance. And I said that is his opinion. So is that why you are saying I should get expunged?
No, wait.
Okay, thank you, Mr. Speaker. Mr. Speaker, the point I'm making, the entire section she referred to the former, the Chief Justice, or Justice Tokono's vetting, where she says that she failed to answer questions. I think that we should expunge that. That's the point I'm making. We should expunge that from the records. Just as you admonish her that she should veer away from it, I'm going further to plead with you to let the Hansard expunge that section completely from the records. Because unless somebody reads your comments, if I'm reading the Hansard and I don't go further to read your comments, I will not know that You have told her to move away from it, and that is not good. I just want them to expunge that section. That's all that I'm saying. The section that goes to say that in her view she has failed those questions, so she expunge it. That's all I'm saying.
Honorable member, I want to hear you again, because if I had heard the use of the word fail, I would have definitely ruled her out of order. What did you say? What did you say?
Thank you very much, Right Honorable Speaker, for the opportunity to correct this. Mr. Speaker, I asked a question to the then nominee, asking her to give 5 attributes of a good Chief Justice, and she mentioned 1. Thereafter, the Saturday after the vetting, Honorable A.B.A. Hussaini was on Joy News Newsfile program discussing the entire vetting process, and he indicated that he thought that the most important question that was asked at vetting was the question asked by Honorable Zuwaira Mohammed Ibrahima, to the effect that the nominee should give 5 attributes of a good Chief Justice. That is what I said. I never used the word fail. Hansard is my witness. They can go back and check. The word fail never came from me, Mr. Speaker. He said he was not. Mr. Speaker. Mr. Speaker.
Honorable members, I've listened to her, and so I'll proceed to direct that if she had earlier used the word fail, that portion be deleted from the official reports, particularly the word fail. Now, she has stated clearly she did not use it, but it's recorded. And so the official reports will go through all this. If they come across the use of the word fail and the words after it should be deleted from the official reports. Please, now you have 1 minute.
Thank you very much, Mr. Speaker. Mr. Speaker, in conclusion, and tying it all into my previous statements, Justice Bafo-Boni made very strong statements at vetting. And one of the things he said that drives my enthusiasm today, and I quote, he said, "The Constitution of Ghana entrusts the Chief Justice with a dual responsibility to adjudicate cases with fairness and to safeguard the credibility and moral authority of justice itself." Mr. Speaker, it gives all of us comfort. And hope. Mr. Speaker, as I said, I watched Justice Bafo-Boni. He spoke from his heart. This is a man who was ready to leave a job at the prison service so he could marry his sweetheart. And he was adverting with Mrs. Bafo-Boni. Mr. Speaker, it tells you the character of the man. So,
honorable members, may we now listen to Honorable members, may we now listen to Honorable Anthony Emia. 5 minutes. 5 minutes. 5 minutes.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, may I place on record that
Gertrude Tokono, throughout her distinguished service as a judge and Chief Justice, had an impeccable record.
Sure.
Not just impeccable, my Lord, Mr. Speaker, sorry. It was also spotless. Unfortunately, we did not give her the chance to exhaust her full term as Chief Justice of the Republic of Ghana. Mr. Speaker, the executive summary before me this afternoon makes capital out of Article 144 of the 1992 Constitution, which has given birth to this exercise and the said report. But in the view of the minority, the said article has been invoked prematurely. And I say so based on arguments advanced by my colleague, Honorable Anyimedu, citing the various cases. What is interesting about the said cases, Mr. Speaker, is that
Honorable member, don't fall into the same trap. That is not before us. And you know that these are matters pending in the court. So you have the right forum to go and ventilate your grievances and as much as possible vindicate yourself at that forum, not in Parliament. Let's proceed with the business before us. That's all.
I am very grateful, Mr. Speaker. Mr. Speaker, I will dwell on our own rules from our standing orders, particularly Orders 103F, 1231, 217, Rule 2, as well as 216, Rule 4, in further proceeding with my comment on the report. And with your kind permission, I would want to read the various orders. Mr. Speaker, Order 103F says, a motion shall not relate to a definite issue, and a motion shall relate to a definite issue and not F. Be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. When you move on to 1231, 1231, which is under content of speech, says, a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way, or may, in the opinion of the person presiding, prejudice the interest of the parties in the action. The combined effect of what's going on? The combined effect of Order 103F and 1231, with a great deal of respect, is to prohibit reference to parliamentary proceedings that could prejudice cases before the court. But in this particular instance, that is exactly what has preceded events leading to today's report. I will not. I will not dwell from what.
Please, honorable members, don't tamper with the mic. You may go on.
Then again, if you move to Order 2172 and Order 2164, part of our own rules. And Mr. Speaker, again, I seek your permission to read Order 2172, which says the chairperson and ranking member and 2 other members of relevant subject matter standing or select committee shall join the members of the appointment committee to consider persons nominated by the President for appointment as Chief Justice and Justice of the Superior Court, Ministers of State, Deputy Ministers, Administrator of the District Assembly's Common Fund, the Special Prosecutor and other persons specified under the Constitution or any other enactment. The 2164 stipulates that the clerk is responsible for arranging questions admitted by the Speaker to conform with the rota and to inform the ministers accordingly. From my understanding, the combined effect of 2164 and 2172 is that, 1, there was no lawful vacancy that is flowing directly from 2172.
Honorable member, you are out of order. Please, your time is up. And we proceed to the next person. Honorable members, we will now listen to Honorable Muntaka Mohammed. 5 minutes. 5 minutes. Honorable members, the timing has been captured by the recordings. The instruments will give 5 minutes exactly. So when it gets to the 5 minutes, it will cut off automatically. That is what happened to the honorable member. And so I had to give him extra minutes. So please, Honorable Muntaka Mohammed, Minister for Interior, take note.
Thank you, Mr. Speaker. Mr. Speaker, I want to thank you for the opportunity, but to remind the House that, Mr. Speaker, I'm not a backbencher, because I heard earlier Honorable Ayimbadu was given 10 minutes, and I thought, Mr. Speaker, I don't know how the leadership agreed, but the most important thing is that ministers are equated to rankings and chairs. So I don't know if that timing could be relooked at, but other than that, I can proceed.
Honorable member, you are actually not a backbencher, but you have been favored to speak instead of a backbencher. That should have been given to a backbencher. So I thought that you should have shown some gratitude to your leaders. If you think that you are oversized, then we'll get proper size for you next time.
Well, Mr. Speaker, I'll thank you and the leadership for the opportunity to speak in place of a backbencher. But Mr. Speaker, my worry is about the conclusion of the report of the committee. Mr. Speaker, as you may know, the House is guided by rules. And all our rules, Mr. Speaker, because of timing, I want to state that if you take Order 217, it says that the committee's report will either be by consensus or by voting. The Speaker, so far as all of us were concerned, there was no voting at the Appointments Committee. Because, Mr. Speaker, as you know, votings are done at the tail end of the matter, whether it's a motion, whether it's a question, whether it's whatever decision is taken at the tail end. And, Mr. Speaker, as we all also know, because of the timing, the rules of the House says that whatever rules that play to the chamber equally plays at the committee level. And, Mr. Speaker, like I'm debating now, I cannot speak now and tell you, Mr. Speaker, when it's time for voting, I'll be voting this way and therefore step out. No, it has to be, I have to be present and be voting, as in Article 104 of our Constitution and our Standing Orders 139. Mr. Speaker, I believe that the committee's conclusion should be that it is by consensus decision. It cannot be by majority decision. It was by consensus decision. But, Mr. Speaker, and the most important thing, as Mr. Speaker, you may know because of your deep knowledge of this House and its rules, if we are at a committee to vote, until somebody raises quorum, quorum is assumed. If it's time for us to vote, and there's nobody to raise issue of whether we have our full membership or what have you, it is assumed. Mr. Speaker, when people walk out, their names will still be recorded as present. When you are going to record those who were present, their names will be recorded. But they cannot say, we are voting, but we are walking out. No. The time that they were saying they were voting was not time for voting. So, Mr. Speaker, I want the House to consider this and amend the committee's report to indicate that the decision was by consensus, so that they do not take more of our time. Mr. Speaker, most importantly on the nominee, for me, I'm wondering why our colleagues are even doing what they are doing. Because, Mr. Speaker, it is very clear by Article 146 of the Constitution, where the President is mandated, if there's petition, to remove a Chief Justice or otherwise, the proper procedure was followed to the end. And if you have a challenge to that, it is not on the floor of Parliament that you come and challenge that. Mr. Speaker, the nominee, if you look at his experience, you and I, Mr. Speaker, with all humility, were members of the Appointments Committee when we vetted him in 2008. I was a backbencher member of the Appointments Committee, and he's been there for 17 years. Mr. Speaker, if you look at his impeccable records, you will be wondering why has he not been Chief Justice long ago. Because, Mr. Speaker, this is one person that has run his career through almost all the government. He got to the bench through President Rawlings, as indicated by even the committee's report. He got to the High Court through President Rawlings. Then, through President Kufuor, he went to the Appeals Court and the Supreme Court. And he's one of the very experienced persons that we have. If you look at his experience, if you look at the things that he's been able to do, even academically, and you wonder why he was not even made a Chief Justice earlier. But like we said, everybody marks his time. This is his time. This is the time for Justice Paul Bafuboni. And, Mr. Speaker, we must support him and encourage him to be able to give out his best, as he himself had indicated in the record. But, Mr. Speaker, I want us to look at the issue of the committee's conclusion, saying that it's by majority decision. Mr. Speaker, I strongly believe it is by... Thank you very much.
Honourable Member, very difficult to accede to your request because you now have to define what voting means. What do you mean by voting? Do you have to use a thumbprint? Can you use your mouth to vote? There are so many ways that you can determine somebody has voted. The report is very clear. It says after the minority leader made his submission, which was preliminary, it stated clearly and is quoted, the minority caucus hereby vote en bloc to reject the nominee. That is at the public hearing. And so, clear indication as to voting. Then, getting to the end of the report, the chairman captured it again, where he says, in conclusion, all the members of the New Patriotic Party minority were opposed to and voted against the nomination of the Chief Justice. That is what we have. And so I'm saying that then you have to define what we mean by vote. Has it got to be a physical indication either by thumb or pen, or could it be by word? And that one, we may have to look at it again. Then he concluded, the chairman, the committee therefore recommends to the House by majority decision. He didn't tell us how the majority came by the decision. And it could be just the discussion there that they agreed that we support the nomination. That will be a decision, and that will be a way of voting. And so once they took that decision and adopted the report, we cannot question that they haven't been voting at the committee level. That is the challenge I have. And so I'll have difficulty in directing that the report of the committee be amended to capture the views that you've expressed. May we now go on to the next person, and that is the Honorable Member for Tampuli Al-Hassan. Tampuli Hassan, your constituency is Gushegu. Gushegu. No. That is his name here. Speaker, yes, please.
I'm sorry, but Speaker, with respect, I submitted the names from the minority. And as far as I can recollect, the next to speak is the Honorable Sami Oku. Speaker, if you may indulge me. That is the list. No, that's the list.
Well, that is what I have here. But when your leader was speaking, he mentioned Tampuli before. But what you actually submitted to me, the third name is Sami Awuku, which is 5 minutes. But in his submission, he mentioned Tampuli first.
I would respect, not to challenge the leader, but we will respectfully require of you that we go by the list. So we will. So
Honorable Sami Awuku,
yes,
5 minutes.
Thank you.
Right Honorable Speaker, let me thank you for the opportunity to comment on the Appointment Committee's report on the President's nominee for the office of Chief Justice.
Are you contributing to it or you are commenting?
I'm contributing to it, Right Honorable Speaker.
Because the two are different. The two are different. If you are going to comment, I will take note of that. If you say you are going to contribute, then I take note.
Right Honorable Speaker, I'm contributing.
You may go on.
Mr. Speaker, I listened to the First Deputy Speaker as he eloquently also touted the achievement of the President's nominee, including his diligence and competence. Mr. Speaker, this is a sharp departure from a previous position when Justice Bafo-Boni was nominated for the office of Supreme Court Judge under President Kufuor. The NDC vehemently opposed it anyway. Mr. Speaker, our position and that of the minority is not premised on personal grounds, but clearly on a matter of principle. Mr. Speaker, pursuant to Article 1446 of the Constitution, it is clear that the judiciary currently is not leaderless. The acting Chief Justice enjoys the powers of exercising his discretion and also the administration of justice. Mr. Speaker, what may likely create some genuine crisis in the minds of people will be the invitation of Parliament in helping install a new Chief Justice and the court subsequently, if matters before it are resolved and goes the other way. Mr. Speaker, for the avoidance of doubt, Article 144 mandates the President, and the President's power to also nominate a Chief Justice is not impaired at all, and it's not challenged. The President has exercised that power by nominating Justice Bafo-Boni. Parliament's approval function, like all other constitutional powers, must also be exercised consistently with other constitutional provisions, Right Honorable Speaker, including the separation of powers, judicial independence, the sub judice rule, and also respect for pending processes. Right Honorable Speaker, Justice Paul Bafo-Boni has less than 2 years to retire. And we respectfully hold the view that this process must also not be rushed. And with all the benefits available to him and the powers available to him as acting Chief Justice, we believe the balance of convenience arguments really can hold sway here. And what is this balance of convenient argument here? If Justice Paul Bafo-Boni is approved by Parliament today, Right Honorable Speaker, and the ECOWAS Court or Supreme Court decides otherwise, Mr. Speaker, the Constitution does not give direction on how to deal with such matters under such circumstances. Mr. Speaker.
Please, Honorable Member, may you move from that and go to the next topic. You have other issues, go to that.
Right Honorable Speaker, it is our considered position, and we hold a view, and in complete fidelity to the law, that we believe that these processes, we can hold on with it and exhaust the processes. And it's on this basis that we join the House and also call on the House as well to reject the nominee. Thank you.
Honorable Member, thank you so much. You are within your 5 minutes. It was just left with some seconds. Thank you so much for being timeous. We now go to the next person, and that is from the majority side, Honorable Dominic Ayine, the Attorney General and Minister for Justice. You, Honorable Minister, you have 10 minutes. 10 minutes. 10 minutes.
Thank you. Thank you, Right Honorable Speaker, for the opportunity to contribute to the motion.
Honorable members, he is not speaking as a backbencher. He is speaking as a middle bencher.
Thank you, Right Honorable Speaker, for the opportunity to contribute.
Sorry. Yes, Honorable Habib.
Mr. Speaker, with respect, you said he is speaking as a middle bencher, but Mr. Speaker, with the agreement we have, middle benchers don't have 10 minutes. Then you have 7 minutes. So, Mr. Speaker, I'm reminded that unless he is speaking on behalf of the leadership, but if the Attorney General is speaking as a middle bencher, he has 7 minutes, not 10 minutes.
Honorable Member, you are right. But what they submitted, I can see they cancelled the Honorable Eric Opoku 10 minutes, and they gave him 7, and rather gave Honorable Dominic Ayine 10 minutes. That's what I have here on the paper. So he is speaking for 10 minutes. Honorable Eric Opoku is given 7 minutes. That's what they have done. Please.
Mr. Speaker, with respect, in our case, we did indicate that the minority chief whip, that is the ship and the whip, slot was given to Honorable Anyumedu. That was the reason or the basis for his 10 minutes. So if it is the case that one of the leadership from the majority front bench is ceding his position or his allocation to the Attorney General, then they should indicate so. Rather than that, none of the speakers, apart from the leaders, have 10 minutes to speak. So they should put that on the record so that it will not be the case that leadership will also speak and then...
I have put that on the record. They don't need to do that. So please, let's move on. You have 10 minutes.
Right Honorable Speaker, thank you very much for the opportunity to contribute to the motion for the approval of His Excellency the President's nomination for appointment as Chief Justice of the Republic of Ghana of the Honorable Justice Paul Bafo-Boni. Mr. Speaker, I have a preliminary observation to make. As was rightly pointed out by the Honorable Zuwaira Ibrahima, I also, the Honorable Member for Salaga South, I also sat through the entire vetting process and observed, sometimes with consternation, about the conduct that was exhibited at the vetting. Mr. Speaker, the Constitution enshrines the doctrine of the co-equality of the three branches of government: the executive, the legislature, and the judiciary. The doctrine of co-equality means also implicitly that the principle of comity, and I'm talking about comity as in C-O-M-I-T-Y, must apply in the relationship amongst the three branches of government. What does comity mean? Comity, Mr. Speaker, simply means courtesy extended towards a person that you respect as a co-equal. Mr. Speaker, on that day...
Honorable Member, you have 10 minutes.
Yes, Mr. Speaker.
Unless you want to tell me...
I will speak within the 10 minutes, Mr.
Honorable
Speaker.
Member, unless you want to tell me that the apology are rendered to the judiciary because of the conduct of some members at the Appointments Committee is not sufficient. Unless that's what you want to tell me, I think that you need to move away from where you are now to another issue. I have done that already on behalf of the whole House. And I did it sitting on this same chair, presiding over this House. So please, don't overstretch that issue again.
Thank you very much, Right Honorable Speaker. I thought rightly that I was adding my voice to your powerful voice about how we conduct ourselves. So I take a cue from you. Mr. Speaker, we on this side of the House, we have no doubt that the President of the Republic appointed the right person to the position of Chief Justice of the Republic. Mr. Speaker, in line with Article 128, Clause 4 of the Constitution, there are three main criteria for qualification as a Justice of the Superior Court. One is high moral character, proven integrity, and that the person should be not less than 15 years experience as a lawyer. Mr. Speaker, the Honorable Chief Justice, the Honorable Paul Bafo-Boni, more than qualifies within the context of Article 128, Clause 4 of the Constitution. He has been a Justice of the Supreme Court or a Justice of the Superior Court for more than 30 years, more than 3 decades. There has been no incident of questionable acts of integrity on his part. Indeed, prior to coming for a vetting, Mr. Speaker, the NIB, or the National Intelligence Bureau, or what we used to call BNI, did background checks on him. And the report came back with a clean bill of health. He is squeaky clean as far as his job as a justice of the Superior Court is concerned. So there are no questions to be raised when it comes to meeting the constitutional criteria. Mr. Speaker, we all know in this country that our judiciary is at a crossroads, that public trust is fast declining when it comes to the performance of the judiciary. Various studies, empirical studies have shown that that is the case. In that respect, Mr. Speaker, you need an experienced hand to steer the affairs of the judiciary and take us out of that storm. And the right person at this moment in time is no other than the person who has served the judiciary with distinction for over 3 decades. Mr. Speaker, when he answered the questions, you could see he did so with brilliance. You could see he did so from an experienced standpoint, somebody who knows the judiciary outside out, and he is a person who will steer us out of the troubles that we are now facing in terms of the institutional performance of the judiciary. Mr. Speaker, what caught my eye as the Attorney General and Minister of Justice on that day was when he was asked a question regarding how he was going to transform the judiciary. Mr. Speaker, I am sure the minority will, do well to listen to what I'm going to say. Mr. Speaker, he gave us 3 cardinal pillars on which he is going to transform the judiciary. He said he is going to introduce rules relating to procedural clarity and flexibility. Second, he is going to introduce efficiency in justice delivery. And third, accountability at all levels of judicial decision making. This is what we need at this point in time in our history. This is what we need for the judiciary to be independent and to perform and deliver justice to the people of this country. Mr. Speaker, on the issue of pending suits, I am, or let me say my office is, a nominal defendant in all the suits. And I know better, looking at the Constitution and our standing orders, than to comment on pending suits before the courts of justice, whether it is the ECOWAS court or it is our own judiciary. But, Mr. Speaker, I want to assure this House and all Ghanaians, our citizens who are listening to us, that nothing untoward, no untoward conduct has emanated from my office. And the minority, with all the experienced lawyers that they have, including but not limited to the Honorable Minority Leader himself, should know that if the Supreme Court comes out with its decision saying that the process of the removal of the Chief Justice was groundless. In other words, there was no ground, there were no legal grounds for the removal. Mr. Speaker, no, listen to this. If orders are made, the President of the Republic, His Excellency John Dramani Mahama, has no option but to obey the orders of the court. In fact, if he does not obey, the Constitution says that that is a high crime that will result in his removal.
Minister and Attorney General, this is an area that I've given a directive on. You have to move away from it and let's focus on the matter before the House.
Thank you, Right Honorable Speaker.
Minority Leader is on his feet, yes.
Speaker, with respect, my respected colleague, the learned Attorney General, made reference
to me in his submissions. To the extent that I feel misquoted, I just want to take the opportunity to correct the fact on record. He contends that the minority, with all its lawyers, including me, have misconstrued the matters at the various courts, and goes on to make further submission that should there be any ruling in favor of the plaintiff, Her Ladyship Justice Tokonu, Mr. President would obey. Mr. Speaker, the gravamen of my contention and that of my colleagues is to the effect that the learned Attorney General's office, with the time given to file defense in the suit, has failed to do so. That was the argument of bad faith we raised, that in ECOWAS court there's a time, and if we really want to enrich our constitution and enrich democracy, that when a person appears before court, parties to the suit, however nominal, would make their views known. And Mr. Speaker, the learned Attorney General, by making inference to my submission, again says that he is merely a nominal. But as nominal as he is the only party the Constitution provides as the one to file a defense. So it was his duty to take issues, traverse the matters, and Mr. Speaker, throughout the period, he did not. And it was the reason why we argued that, look, having failed to do that on time, you've created a certain lacuna, you've created a certain situation that goes against the rights of the respected former Chief Justice. That was the contention. I was not raising any other thing, but rightly saying that if you had failed on time, especially when you were served with all the processes on time, look at the way the injunction application was speedily heard. The substantive matter was pending long before vacation, and even after legal vacation, you didn't file a defense. You later went to the court to file a process for leave for extension of time, to file your process out of time. Meanwhile, we were receiving a nomination. Meanwhile, Parliament was again bound to hear the nominee. This was the argument we made, and it was not to attack the issue before the court. It was the action of your office, and that is why we raised it. So, Leonard Attorney General,
Minority Leader,
yes, Mr. Speaker,
we have heard you.
Very well.
Heard you.
Very well.
Please, I was compelled to give him time because you referred to it, and it's not a matter, as I directed earlier on, that is of concern to the motion that is before the House. So kindly move away from there and then make your submissions. I've taken note of the interjections, and you have enough time to make your submission. Please, you may go on.
Mr. Speaker, thank you very much. There is a point of correction, and because we are a house of record, Mr. Speaker, I think it is very, very important. The Honorable Minority Leader himself knows very well that the rules of court, CI 16, supplemented by CI 47, the High Court Civil Procedure Rules, accords lawyers the opportunity to apply for extension to file their processes out of time. This is not something strange, and there is nothing sinister in what we have done. So, Mr. Speaker, in rounding up, I wish to employ all of you, my colleagues in this House, that we approve the President's nominee because he is ably and eminently qualified in terms of Article 128, Clause 4 of the Constitution. He is one of the most experienced justices of the Supreme Court that we have, and his experience is definitely needed at this point in time in our history
in order to
Honorable Minister, you are timed out. Yes, may we go to the next speaker now, and that is Honorable Tampuli Hassan. You have 7 minutes. Honorable member, please. I was trying to get the second deputy speaker. I just recollected he's on an assignment. So may you kindly give me just 5 minutes. I'll be back and then you make your submission. Sitting is suspended for 5 minutes.
we shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity. Mr. Speaker, it continues, in a spirit of friendship and peace with all peoples of the world, and in solemn declaration and affirmation of our commitments to freedom, justice, and probity and accountability. The principle that all powers of government spring from the sovereign will of the people, the principle of universal adult suffrage, and Mr. Speaker, my emphasis, the rule of law, supremacy of the Constitution, equality before the law, and respect for the fundamental human rights and freedom of our people. Mr. Speaker, in terms of fundamental human rights of the people and access to justice, Mr. Speaker, embedded in that rule of law thing is the accessible and impartial justice. Mr. Speaker, we must be given usable opportunities when we think our rights have been violated to be able to vindicate our rights. Mr. Speaker, one of the things that we must advert our minds to is that when there are pending matters, it's important that I am allowed to finish the process before a decision will be taken that will prejudice my rights. And Mr. Speaker, we are not saying this because this is Justice Tokono, but this right must be available to every one of us and every Ghanaian. Mr. Speaker, fair legal procedures. Mr. Speaker, if I take a matter to court, I have every right to complete the matter before I'm told that my issue is foreclosed. Mr. Speaker, if matters are pending before courts and you leave the office, Mr. Speaker, Article 1446 provides situations where a justice of the Superior Court, including the Chief Justice, may lose office. Stated misbehavior, incompetence, and inability to perform the functions of the office. Mr. Speaker, what we are saying is that if we go ahead to confirm Justice Paul Baffour Boni and he becomes the Chief Justice, and in the event that the pending cases terminate in her favor, what happens to that office? Mr. Speaker, we anticipate that there will be constitutional nuclear meltdown, and that is what we intend to avoid.
Honorable member.
Mr. Speaker.
Honorable member, please. I don't know how many times I have to draw the attention of members to this matter. That is not what is before us. Finality of the rule of law is pronounced and is in the bosom of the courts. Legislative power, the power to make laws, is in our bosom. The Constitution added the power to approve, that is, give prior approval to nominees by His Excellency the President. And that is exactly what we are doing. As to whether our decision is the final rule of law, is for another body to determine. And so the proper venue, and I keep on emphasizing that, it's not this house, it's the court. And so please, once you have the matters pending there, the matters will continue to pen there, and you can vindicate those rights there. The judiciary cannot say that because Parliament is considering a bill that may have some effect on a matter before the judiciary, they'll have to hold on until we pass the bill before they proceed with the matter. They can't say that. The same, I'm just putting it in simple language, that once a matter is before the judiciary, they can't say because that matter is before the judiciary, Parliament is stopped from also performing its function of lawmaking, of right, of these approvals and the rest until they finish adjudicating the matter. So we have to go on with ours. And that is exactly what we are doing. We cannot be stopped. I have given my ruling on this, and you are bound by it. If you are not, you know the rule in our standing orders. You know what to do. If you are not satisfied with that, you also have the courts to go and vindicate your rights. But so far as the matter before us is concerned, let's stick to that matter. Let's go on with that, and then later on you can proceed with whatever you want to do. But for me as Speaker, I preside. I don't judge. I preside. And I'll preside and make sure that what the rules say should happen will happen. At the end of the day, the House will be given the opportunity to take the decision. The rest, you can proceed on after that. Please. So let's move on to the matter before us.
Thank you, Mr. Speaker. Mr. Speaker, I'm guided. Mr. Speaker, next I would like to refer this House to Article 1254 of the Constitution, where it says that the Chief Justice shall be subject to the Constitution as be the head of the judiciary and shall be responsible for the administration and supervision of the judiciary.
I told you about the timing. When there was the interjection, it stopped. It's automatic. It's not being controlled by me. Please, kindly give him 1 minute. 1 minute.
Thank you, Mr. Speaker. Mr. Speaker, what that provision provides for is that we are not looking at the Chief Justice capacity as a justice of the Supreme Court, but as a head of the judiciary in terms of the human resource, planning, organizing, directing, control, and discipline of the judicial human resource, the judicial service staff, including even judges. Mr. Speaker, one would be not too far away if you ask the acting Chief Justice whether or not he will be transferring judges, whether or not if a justice of the Superior Court, conducts himself or in any way he will be taking action against the person, or whether or not any disciplinary action can be taken anybody as a judge or any staff of the judicial service. Mr. Speaker.
The 1 minute is over again. So, but honorable member, don't be worried about that, because even this constitution, when it was being drafted, it was said to be drafted by hairdressers. Now, when it was approved, the people who stated that the hairdressers were drafting constitution kept on applauding the good works of the hairdressers. So, and you have also done that today. It's just that politicians are a different breed of human beings. So that is the challenge we have in the world. May we proceed to the next person, and this time from the majority side, and that is Honorable Eric Opoku. Honorable, you have seven minutes.
Thank you very much, Mr. Speaker, for the opportunity to contribute to the motion before this House. Mr. Speaker, this House is witnessing inconsistency in its highest apogee. Inconsistency that has never been seen on the floor of this House, except today. Mr. Speaker, you recall that in the last year of Mr. President John Agyekum Kufuor, 2008, Justice Paul Bafuboni was elevated to the position of Supreme Court Justice And the Appointments Committee's report was submitted to this House for approval. Mr. Speaker, that day, records of this House indicates that the minority we see today, they were in the majority. And they extolled the virtues of this man right in this chamber. They described him as competent. They described him as competent, a man who has served this nation with dignity, an honest judge. In fact, they said a lot of good things about this man. Mr. Speaker, what has changed? What has changed? Today, the same person has been elevated, and now you are opposing his nomination. History will be the best judge. Mr. Speaker, again, I heard Honorable Enyimadu spoke about executive manipulation of the judiciary. Mr. Speaker, you recall that between 2003 and 2006, Justice Paul Bafuboni was appointed to the Fast-Track High Court. He was appointed to the Fast-Track High Court, a court established by President Kufuor, tried some cases, and after some years, declared unconstitutional in the history of our country. That was the period of executive manipulation of the judiciary. That was the period. And it happened under your watch. And today you have the courage to sit in the same chamber and talk about executive manipulation of the judiciary. Mr. Speaker, again, you are ruling on the matter, on this matter, is fortified by this report.
Honorable member, please. May we listen to, yes.
Mr. Speaker, very respectfully, I stand on Order 122 to clarify a point. Mr. Speaker, we don't appoint to the Fast-Track High Court. We appoint to the High Court. So, Mr. Speaker, that clarification would have to be clear. There's nothing like we appoint to the High Court and not the Fast-Track High Court. When you are appointed to the High Court, you are then assigned to a division of the High Court. Mr. Speaker, this is the point. You don't appoint to the High Court.
Mr. Speaker, Mr. Speaker, Mr. Speaker, it is in the report, page 8. Page 8 of the report. Listen. Page 8 of the report. He was elevated to the High Court in 2000, serving at Sunyane and Kumasi between 2000 and 2003, and later appointed justice to the Fast-Track High Court. Is it the report? So what's your problem? So, Mr. Speaker, I was speaking to the report, exactly how it is captured in the report. Now, Mr. Speaker, you are ruling on the matter that while Parliament is discharging a lawful duty, no court action can stop that. Is fortified by this report. And it's interesting we raise this issue for Ghanaians to know. Mr. Speaker, paragraph 27 of the report.
Honorable member, your leader is on his feet.
Okay.
Yes, please.
Mr. Speaker, I have been trying very hard to get members on this side to listen to opposing views. I urge our colleagues to also pay attention and listen so that so that we can expedite action on this matter. I'm just appealing to our colleagues on the other side.
Honorable members, please, we need to listen to each other. Honorable Doctor, he represented Parliament at our march against the judiciary. He was among the 11, and he ran all over the field without touching the ball. And he was substituted. So I understand that. Honorable members, please, we only consider and give prior approval to nominees of the President to the Supreme Court. The High Court and the Court of Appeal don't come before the House for prior approval. Please, that is the state of affairs. The process that he went through, I was minority leader. Concerns were expressed, but this was not a matter that came before the House for his approval or otherwise. Not at all. Please, let's go on.
Thank you very much, Mr. Speaker. Mr. Speaker, I was saying that reading page 27 of the report, under point 6.18, propriety of proceeding with the vetting process. Your committee has reported, and indeed they have cited two major cases, one involving a member of this House, Honorable Vincent Asamoah versus Attorney General, and the report reads, to substantiate his position, the nominee cited relevant legal precedents, including Dufour versus Bank of Ghana and Vincent Assefuah versus Attorney General, both of which affirm the principle that the existence of a legal challenge does not suspend constitutional processes in the absence of an explicit court injunction. Mr. Speaker, these two cases.
Honorable member, I ruled on that, so let's move on.
Mr. Speaker, I'm moving on because our colleagues, when I raised the issue, that the same person, when he was brought here, they extolled his virtues. They said no, they are not opposed to his nomination, but they are talking about some legalities. And the basis of their argument is that there is a case that is to stop the proceedings of this House. And I'm reading this to fortify your ruling that they don't have basis. Their argument is baseless. They are only talking because they are in the minority and they want to be heard. Otherwise, they'll have no case at all to be even making noise in this House. The truth of the fact is that the man qualifies, he is competent. In fact, he is the first son from our region, Ahafo, to be elevated to this position. And the people of our region are solidly behind him. And so we urge our colleagues on the other side that you cannot oppose everything on this earth. You were here defending some few days ago. Now you are transmoging.
Honorable members, we move on to the next person, and that is the last from the minority caucus, and the leader himself wants to take up that task. So I call on Osahene Afenyo-Markin.
Mr. Speaker, thank you for the opportunity to add my voice to this debate on the floor. Mr. Speaker, in making my contribution, I would want to, in addition to the report, rely on the certified copy of the verbatim report of proceedings that has been served on my good self by the clerk through the chairman. And for the avoidance of doubt, I would want to make same available to the table office for the record, because I'm going to rely on same. Mr. Speaker, that said, I shall proceed to say that for the first time under the 1992 Constitution, a sitting Chief Justice has been removed pursuant to Article 146 of the Constitution. Mr. Speaker, that removal effected on 1st September 2025, following recommendation by a committee chaired by His Lordship Justice Gabriel Puaman, has generated unprecedented litigation challenging its constitutional validity, procedural regularity, and legal effectiveness. Critically, several proceedings were filed before Her Ladyship's removal was finalized. These are contemporaneous constitutional challenges asserting fundamental and irredeemable flaws in the Article 146 process. The removal proceeded despite these pending objections. These objections now remain unresolved before multiple courts of competent jurisdiction. Mr. Speaker, we, the minority, hold the view that there has been inconsistency in the approach in this matter, and that if care is not taken, this country that we all seek investment for may not attract that needed investment. Mr. Speaker, as we speak, the prima facie findings of the Council of State remain unpublished. 2, as we speak, the report that recommended...
Honorable Member.
Mr. Speaker, my submission is to the effect that the matters giving rise for this motion to be taken are such that we, the minority, still believe that there are serious matters for the Constitution of our Republic. Mr. Speaker, and I say so because today we consider this nomination, and you have made it clear that our approval or otherwise does not bring a finality within the context of the rule of law. Which I agree, I'm not contesting that. But it is our view that gave rise for the final decision of His Excellency the President is also not in the public domain, is of concern to us. Mr. Speaker, we contend that for the purposes of transparent democracy, the era where the citizens require information, it should have been an instinctive, inherent
of another arm of government.
Mr. Speaker, I hope my time is being stopped.
Not Parliament. Not Parliament.
No.
And those matters are not before Parliament. And so I have consistently guided you and your colleagues to deal with the matter before Parliament. Continue with the others at the proper forum not the floor of Parliament.
Mr. Speaker, we are not litigating those matters in Parliament, but those matters gave rise to this, what is before us. So what I'm trying to do is to give a background to the very matter before us, Mr. Speaker. Mr. Speaker, the Honorable Eric Opoku in his submission argues with some force that executive manipulation started in Kufuor era. I found it very rich. And he tries to use that to justify the concerns that we are raising, to say that we are acting in double standard. No, Mr. Speaker, in President Kufuor's era, no Chief Justice was removed. Mr. Speaker,
Honorable member,
Mr. Speaker,
please. I don't want us to go beyond what is before us, because many of the things that you say, because many of you were not born early, you don't know, you don't have the information. And in fact, I have bought some books, and I'm going to distribute the books particularly to leaders, so that you read to see the perception that we have given to the people outside there. They are very senior, intelligent people who held high office of state, who have written some books about Ghana politics. I have the books. I bought plenty copies to distribute to you free to read. I believe that will change your approach to how you go about the business on this floor. The information that I have from experience in this house, if I disclose them, many of the things you say are incorrect. The presidents and former presidents, they know. You don't know. And they know that I know what I'm talking about. So please, confine yourselves to the matters before the House. Let's deal with that one.
Mr. Speaker, we are saying that the fact that there appears to be some right violation against Justice Araba Isaba Tokunu, we in the minority are unable to support this nomination. Mr. Speaker, the learned Attorney General, in his submission, alluded to the fact that even when Parliament approves this nomination and the court determines otherwise, the executive would be bound to respect it. He was right in saying that when a court makes a pronouncement, the executive will be bound by it. But what he did not say is the conduct of his office in the handling of the very matter that he is saying when there is pronouncement, they would be bound by it. Mr. Speaker, he himself submitted that the rules of court allows for extension of time application to be made. The question we ask is that why didn't the Attorney General, considering the enormity of this matter, act with alacrity? Mr. Speaker, the question that begs for an answer is that for all these periods, if justice was really meant to be done, why didn't the Attorney General file a defense? He is now saying that we shouldn't worry, and that if there is any positive outcome, the president will be bound by it. But we are interested in the process. The minority in this house is interested in the process, and it is contending that his actions amount to bad faith and denying the respected
Honorable Minority Leader.
Learned
Honorable Minority Leader.
Yes, Mr. Speaker.
I acknowledge that the minority is interested, and you are expressing your concerns. And those concerns have also been expressed at the right forum. But I say this is not the forum for that. The Attorney General's conduct of conducting proceedings in that court is not before the House. That at all is not. And so please, let's handle what is before us. Then at the appropriate forum, which you are doing, you continue with it. You can just refer that this is what you are doing, but don't go into the details.
Speaker, with respect, Mr. Speaker, just place my time on ice for us to interrogate this preliminary matter. Mr. Speaker, well, I will leave it to you, but I would want to learn. Mr. Speaker, in my submission, I was responding to the Attorney General. These are facts that he has made known to the House. So I was responding to his own argument. I was not saying anything new. It is what he said that I was referring to. But if you say I shouldn't delve deep into it.
I stopped him.
Mr. Speaker, very well.
I stopped him.
Very well.
And I said he should come back to the subject matter on the floor.
Very well. Mr. Speaker, that's
please.
All. Mr. Speaker, if it is so, I will not belabor. Mr. Speaker, today, our colleagues who vehemently opposed just 2 nominations to the Supreme Court, and when they had the opportunity, they brought 7. Their principled argument vanished into thin air. Today, Mr. Speaker, when our friends in the NDC argued against 2 nominations to the Supreme Court, when they had the opportunity, they brought 7 at a go. Today, the same people who opposed this nominee in 2008 are today saying that they are for his cause. Mr. Speaker, we leave everything to posterity. Every single thing that we are witnessing in this house is for posterity. But we believe as minority that in spite of all that is happening, which happenings is affecting the right of a citizen, the best days of our country are ahead of us. Mr. Speaker, we would not belabor. We maintain our opposition to this nomination, and we reject same, and we are going to demand a secret ballot to reject this. We are going to demand a secret ballot to vote, to let Hansard record our opposition. Mr. Speaker, we know that there are members who have their own views and would want to exercise their right when there is secret ballot. We, the minority, are going to invoke that so that we take a secret ballot to register our dissent on this matter. Mr. Speaker, I wouldn't exhaust the 15 minutes. I will submit here to and then leave the matters to rest. Thank you so much.
Honorable members, the last person to have a say on this matter is the majority leader. The minority leader actually used less than 15 minutes. So it's the majority leader who is now to end the debate, and he has 15 minutes to do so.
Mr. Speaker, mine is a very brief one. Very brief. In 2012, we had a national election for the presidency and for parliament. The election results were disputed. President Akufo-Addo was declared winner. John Dramani Mahama and the NDC petitioned President John Dramani Mahama was declared winner. Akufo-Addo petitioned the courts. Mr. Speaker, in 2020, we had another election, and President Akufo-Addo was declared winner, and John Dramani Mahama petitioned. The cases traveled before the Supreme Court, and finally, the Supreme Court made a pronouncement. Mr. Speaker, it was clear to every Ghanaian that in spite of the cases pending in the Supreme Court, we went ahead and swore in those declared by the Electoral Commission as having been validly elected. But the case went on, and in the case of the petition against John Dramani Mahama, it was in August 2013 that the Supreme Court handed a ruling. Mr. Speaker, when we put the question to the nominee as to what he thinks will happen if the previous Chief Justice's case turned out in her favor, he simply referred us to these two cases. If in a presidential petition, we are convinced that if the ruling goes against a sitting president, that person will vacate the seat so that the winner will take over. Why would we entertain doubt that if a Chief Justice who has left office gets a ruling in her favor, that the sitting Chief Justice will not give way so that the decision of the Supreme Court will be enforced? So the answer is simple. We have to proceed. And when the decisions of the courts come, and the implications are that what has happened should be reversed, the Chief Justice nominee said he is ready to give way, and whoever the courts declare in favor of will come and occupy the post of Chief Justice. So there's no problem. Mr. Speaker, the second issue about the listing of cases was put to the nominee, and the nominee explained that he, as acting Chief Justice, is not responsible for listing cases. So if the minority's position was that some cases hadn't been listed, then that is a matter for the registry, because as an acting Chief Justice, the Chief Justice normally empanels the court when the registrar indicates that all the processes had been concluded, and then
we had reached a stage where we would need to empanel a court. So he wasn't responsible for cases not listed. Mr. Speaker, I think that a lot has been said already about the nominee, and I will not belabor the point, except to once again, lastly, register the point that in 2012, July 24th, 2012, Justice Theodora Wood was nominated, approved by this House, and appointed a Chief Justice. 2013, January, President John Evans Atta Mills, under the NDC, became president. He coexisted amicably with Justice Theodora Wood, who was appointed by President Kufuor under the NPP. Mr. Speaker, again, on 24th of July, 2012, when we lost the president, John Dramani Mahama took over as the president, and he coexisted amicably with Justice Theodora Wood, who was appointed by President Kufuor, an NPP president. What is my point? My point is simple, that the NDC under President Atta Mills and under the current president, John Dramani Mahama, has coexisted peacefully with a Chief Justice appointed by the NPP. So, Mr. Speaker, let me conclude by saying that my colleagues have already argued and given reasons why we should approve the nomination to the post of Chief Justice, because essentially he qualifies under Article 1284 of the Constitution, has been a judge for 30 years, overly qualified, has been a Supreme Court judge for more than a decade and a half, and is now acting as the Chief Justice. Mr. Speaker, without saying more, I will just say that put the question and we will vote. Thank you, Mr. Speaker.
Honorable members, honorable members, at the conclusion of the debate, I put the question. Those in favor of the adoption of the committee's report, say aye. Those against, say no. Honorable members, I put the question again. Those in favor of the adoption of the report of the committee, say aye. Those against say no. Honorable members, I think the ayes have it. Honorable members, we have the Honorable Deputy Whip, Minority Deputy Whip on his feet. Let's listen to him.
Thank you, Mr. Speaker. Mr. Speaker, I rise under Order 1513. Mr. Speaker, Order 151. Mr. Speaker, I rise under Order 1513. Mr. Speaker, with your leave, I read Order 1513. A member may challenge the decision of the Speaker on a voice vote, and the Speaker shall determine whether to call for a head count or electronic vote. Mr. Speaker, I invite you for us to do a head count on this since our electronic vote is not working. Speaker, head count.
Honorable members, there's a challenge to my decision on the voice vote, and there's a call for us to take a head count. Yes, Majority Leader.
Mr. Speaker, let me read Order 1513. Well, it says, a member may challenge the decision of the Speaker on the voice vote, and the Speaker shall determine whether to call for head count or electronic vote. Whether. Mr. Speaker.
Keep quiet.
Whether. Mr. Speaker. There is no automatic right to a head count or electronic vote when somebody challenges the voice vote. There's no automatic right. It is for the Speaker to look at the chamber. Because where Mr. Speaker sits, he sees the numbers. Where Mr. Speaker sits, he sees the numbers. He sees the number constituting the NPP votes, and sees the number constituting the NDC votes. And Mr. Speaker knows that the NPP micro-minority have already indicated they are voting against. The NDC supermajority has already indicated they are voting for. So when you look at the numbers in the chamber, it is so clear that it becomes unnecessary for a head count. Mr. Speaker, so Mr. Speaker, we have confidence in you and your understanding of the rules. The rules say that a member may challenge the decision of the Speaker on a voice vote, and the Speaker shall determine whether to call for head count or electronic vote, or whether not to call for head count or electronic vote. Mr. Speaker, it is obvious, and there's no need for you to call for a head count or an electronic vote. It is obvious that they have lost the vote. We've won the vote, and take a decision and let's proceed. Thank you, Mr. Speaker.
Honorable members, I have determined that there should be a head count. So we are going to do a head count. Head count. Please.
Thank you, Mr. Speaker. Mr. Speaker.
Honorable members.
Mr. Speaker.
We are going to do a head count.
Mr. Speaker.
Please, those in favor of the motion, please rise up to be counted.
Mr. Speaker. There's a problem, Mr. Speaker. Mr. Speaker, I want to draw your attention. Mr. Speaker, I want to draw your attention to the Constitution in Article 111. Mr. Speaker. Mr. Speaker, the Constitution in Article 111.
Mahama Bako Nimba Bebre.
What is the challenge? Please, honorable members, be at your seats. Members are moving around and they are having a challenge in counting you. Please, say rise up, rise up. Please. Honorable members, you may resume your seats. Resume your seats. Honorable members, those against the motion rise to be counted. Please, clerks at the table, you are asked to count all those who have risen. Please, so any person that has risen and is standing should be counted. Honorable members, you may now resume your seats. Resume your seats. Honorable members, at the count, the ayes have 163. The noes 69. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, I rise under Order 1526. Mr. Speaker, I rise under Order 1526. Mr. Speaker, for the avoidance of doubt, I read. Order 1526 states that where a member rises to challenge the results of the head count, the Speaker shall call for division. So, Mr. Speaker, I therefore challenge the head count, and I call for you to apply Order 1526 as stated in our orders for division, Mr. Speaker.
Honorable member. Majority Leader.
Mr. Speaker, the member rose and quoted Order 1526. And I just heard him read, where a member rises to challenge the results of the head count, the Speaker shall call for a division. I have not heard him challenge I did not hear him challenge the head count. I did not hear. I did not hear him challenge. I did not hear him challenge. You did. He told him. I did not hear him challenge. I did not hear him challenge the result of the head count. So, Mr. Speaker, let him come properly. I did not hear him. But Mr. Speaker can give a ruling if you heard him challenge the
the result of the head count. I did not hear him.
Yes.
Thank you very much, Right Honorable Speaker. Mr. Speaker, I rise to plead with you and draw your attention to Order 154, which states, and I read, despite Order 153, the Speaker may, if in the opinion of the Speaker, a division has been unnecessarily claimed, take the vote of the House by calling upon the members who support or who oppose the decision of the Speaker to rise and be counted, upon which the Speaker shall declare the decision of the House or direct that a division be held. Unquote. Mr. Speaker, in drawing your attention to this order, I plead that you exercise your authority as expected in that standing order, given that the numbers after the count speak for themselves and the call for a division is an unnecessary request. Mr. Speaker, I thank you.
Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, when I rose earlier on, Mr. Speaker, Mr. Speaker,
Yes.
Mr. Speaker.
Yes, go on.
Mr. Speaker, when I rose earlier on, it was under Order 1526, and that I challenge, and it reads that where a member rises to challenge the results of the head count, the Speaker shall call for a division. Mr. Speaker, therefore, I challenge the results from the head count and call for a division under Order 1526. Mr. Speaker, even though the honorable member for Tamale North, Honorable Soyini, drawing your attention to Order 154. Mr. Speaker, Order 154 is clear that despite Order 153, I haven't raised anything under Order 153. I am within Standing Order 1526, which is mandatory to the Speaker, Mr. Speaker. I make my case. Thank you.
Honorable Member, I'm still waiting to hear your challenge.
Mr. Speaker,
it's not sufficient to say a challenge.
Mr. Speaker, Mr. Speaker, to make my earlier on, I tried to draw your attention. Mr. Speaker, I made this challenge because number one, Mr. Speaker, I did not believe that the number as presented to you from those who voted for the yes or the ayes were up to the number presented to you, Mr. Speaker. And also, I was drawing your attention to Article 111 of the 1992 Constitution. And Mr. Speaker, I read Article 111. The Vice President or a minister or a deputy minister who is not a member of Parliament shall be entitled to participate in the proceedings of Parliament and shall not be accorded the privilege of all members of Parliament except entitlement to vote. Mr. Speaker, the time we were taking the vote, the Ashanti Regional Minister is seated there. He's still here. Mr. Speaker, the Works and Housing Minister is still seated here. He has no right to vote. That's my basis for my challenge, Mr. Speaker.
Yes, Majority Leader.
Mr. Speaker,
Mr. Speaker, Mr. Speaker, Order 153 and Order 152 and Order 154 must all be read together. Because Order 154 says that despite Order 153, the Speaker, if in the opinion of the Speaker, the Speaker may, if in the opinion of the Speaker, a division has been unnecessarily claimed, a decision has been unnecessarily claimed, take the vote of the House by calling upon the members who support or who oppose the decision of the Speaker to rise and be counted, upon which the Speaker shall declare the decision of the House or direct that. Mr. Speaker, if you read Order 153, it deals with division and says the Speaker shall direct that the lobbies be declared in the case of a division. The division bell shall be rung for 1 minute. The Speaker shall invite the leadership of the majority, minority, or independent caucuses to appoint 2 tellers each to observe the division process. After a lapse of 5 minutes, the Speaker shall announce the names of division clerks and the tellers. So 153 deals with the procedure for division. Is that okay? And 154 says that in spite of the fact that there is a procedure for division, Speaker can also say that a division has been unnecessarily claimed. That's 154. And if the Speaker, he would ask one side only to rise up and be counted. Just one side. He can say that because you are not many and you are just 69, it is easier to count you. So you should rise up and then he will count you. When he counts you, he can direct and declare the decision of the House. That is what 154 says. That's what 154 says. So I therefore call on Mr. Speaker. I therefore call on Mr. Speaker to rule that a division has been unnecessarily claimed, and on the basis of a ruling that a division has been unnecessarily claimed, to proceed to count one side and then declare the decision of the House. Thank you, Mr. Speaker.
Honorable members, Minority Leader, yes.
Yes, I think I mentioned it to you before.
Speaker, with respect, the Honorable Member for Tolon invoked Order 152 and was very clear in his application. The Order 153 that provides for procedure on division anticipates that possibly the 151 that was initially involved. Mr. Speaker, in the first instance, it is the clerks who have done the accounting, not independently verified by anybody, and they have brought the figures to you. The member has challenged it, and that is why the second stage step allows for agents, that those who are saying no, those who are saying yes, will have an opportunity to validate the counting process. Mr. Speaker, for the majority leader to immediately invoke 154, to say that 154 says, despite 153, Speaker may. Mr. Speaker, that provision there must not be construed in a manner to negate the mandatory obligation under 1526. No, it is saying where the number, if you read 153, 11 and 12, it says that if a member states that he voted in error and that his vote was counted wrongly, the member may request that the vote be corrected or counted before the speaker declares the result. 11, where the member numbers in a division are equal, the motion shall be considered lost. Now, Mr. Speaker, if you read these together, it is rather dealing with a situation where a declaration is made under 153 and the speaker would want to exercise a discretion where a member is unnecessarily making a claim under division, because it anticipates that a member may not be satisfied and may be taking certain steps to make a certain application. If they don't move away to refer, Parliament would have said so. It did not say that despite order 152, provision does not make reference to it at all. If the lawmakers had intended the 154 to have effect on 1526, it would have said so in clear language. Mr. Speaker, what has not been written or said is not meant to be added to the whole lot for interpretation. What 154 contemplates is the 153. That is why it mentions 153 without more. Nobody should attempt to lead Mr. Speaker astray. There is a huge temptation. There's a huge temptation. Earlier, the majority leader said Honorable Habib did not challenge. So he didn't hear. Now he moves away. He moves away to now invoke 154. The 154 is contemplating 153. Mr. Speaker, I would not want us to further delay this. 1526 is mandatory, and I'll conclude on it. It says where a member rises to challenge the results of the head count, the speaker shall call for a division. I don't know why the super majority is afraid. What are you afraid of? What are you afraid of? If you have your numbers and you believe in your numbers, let's go into division. If you believe in your numbers, let's go into division.
Honorable Minority Leader, you have made your point. the Honorable Habib mentioned a particular member. I just want to know whether the member was present when the head count was being taken. Please, I want to know from the member, please, it's not from any of you, is a member present? Please, I want to hear from the member. Yes, honorable member.
No, come here. Come and use this one. Come and use this one.
Honorable member, yes.
Okay, you come and use it. Man, so who there? So just speak straight.
Mr. Speaker, respectfully, during the head count, myself and the Honorable Minister for Works and Housing, we were both outside the chamber. We were not counted during the head count. Thank you very much.
You walk them out. What of this one? What's it?
Yes, honorable members, it's my view that the division has been unnecessarily Honorable member, the division has been unnecessarily claimed. Honorable members, please resume your seats. Honorable members, the motion has accordingly been adopted. This honorable House has accordingly approved the nomination of Justice Paul Bafubone as Chief Justice of the Republic in accordance with Article 1. (114) clause 1 from the day of the nomination up to his approval, I should say prior approval by Parliament, into consideration in his tenure of office. Once again, congratulations. Yes, please, First Deputy Speaker.
Right Honorable Speaker, thank you very much for giving me the opportunity. I rise to thank the committee sincerely, particularly those who were present and vetted the nominee. I also want to thank the House, particularly those who were on their feet to be counted in favor of the adoption of the report of the committee. Thank you very much. God richly bless you.
Honorable members, honorable members, honorable members, please, I have a statement. It is actually what we call corrigentum. On 10th November 2025, I had the pleasure and honor of receiving a delegation from the Queen Mother's Foundation, led by their president, the Queen Mother of Kayira in the Ofinsu traditional area, Nana Ama Sewa Bonsu. Their well-intentioned visit afforded us the opportunity of discussing some proposed constitutional amendments, ways of empowering chiefs and queen mothers to protect the environment, stop illegal mining, and facilitate development. However, in communicating their visit to Parliament, I inadvertently referred to Nana Ama Sewa Bonsu as the president of the Queen Mothers Association and Queen Mother of Ofinsu. I wish to apologize to the Ofinsu Traditional Council and the Queen Mothers Association of Ghana for the regrettable error. Let me reiterate that Nana Ama Sewa Bonsu is the president of the Queen Mothers Foundation and not president of the Queen Mothers Association. She is also the Queen Mother of Kayira and not Queen Mother of Ofinsu. As a chief myself, I appreciate and respect traditional protocols and will be the last person to disregard the authority vested in our chiefs and queen mothers. I always welcome every opportunity to meet traditional authorities to discuss ways of exalting their roles in governance and in making them the fulcrum of development in the country, particularly in their jurisdictions. With all humility, I say Kafra Kuse to our revered kings and chiefs, queens and queen mothers of the Ofinsu traditional area. I thank you for your listenership. Honorable members, we will take one item and then take a short suspension before we come to the main item of today. On the order paper, we have this bill that we have been working on for some time now, and it is as item 13 on the order paper, the Ghana Scholarships Authority Bill 2025 is now got to the third reading. I have not received any request for it to be taken to a second consideration stage. So I want us to take it now before we go on the suspension. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, just to remind you that we had agreed that motion 15 on page 4 of today's order paper be taken. Mr. Speaker, I understand that.
Yes.
Mr. Speaker, if you could permit me to move the motion now before the Minister responsible for education will do the Scholarship Authority Bill. Mr. Speaker, I'll be very snappy on my motion. It has been there for very long.
Please, I'll have to then suspend for 5 minutes. The House is sitting is accordingly suspended for 5 minutes.
See my people for just 2 minutes. Yo.
was holding
the Minister Peter Chenasa.
No.
Yes, sir.